Findings of fact and conclusions of law petition to compel arbitration with substituted appointment or disqualification of AAA. Cases where courts compelled arbitration and appointed substitute arbitrators when AAA/institution failed to perform.
Hey, how y'all doing? How y'all doing? How y'all doing? Whew! Got something to talk to y'all's about. I did an arbitration. A U.S. bank decided that they wanted to play, and I don't mind them knowing about this. That's why I'm doing it, to let them know. I told them to leave me alone. I told them I'm coming. I said, I'm not that guy. They said, we don't give a... I said, okay. No. Okay, don't worry about it. I don't want to hear it. When the time comes, I don't want to hear no begging. I don't want to hear no, but we're sorry. I don't want to hear Jack, because Jack ain't got nothing to do with this. All right? So, I created my GPT. Well, I created several. And the presumption killer, ladies and gentlemen, all it does is rebut presumptions. It doesn't give legal advice. So it doesn't violate OpenAI's policy. They finally understand that. At least my hope is they do, because if they mess with me again, then I'm going to do the same thing to them. They sent me a notification. I did the video. It'll be up on the 10th with this one, telling me that I violated their policy, that I was engaged in fraudulent activity. I told them. That's what a U.S. bank charged me with. They said they accused me of attempt to defraud. Who are you saying I'm trying to defraud? I'm just withdrawing money from my account. And they asked me, well, what are you going to use the money for? And I told them, that's none of your business. And he got mad. This was a Hispanic boy. He was substitute manager for that particular branch. I told him, I said, look here, this is my company, because it was my company. And I said, what I do with my money is my business. Because, see, as a person of color, you don't ask us what we're doing with our money. That ain't none of your mother. Excuse me. I tried to explain to him, but he didn't care, because he saw skin color. He's wondering why I'm sitting up there messing with $40,000. I'm like, that ain't none of your business what I'm doing with this money. He was accusing me of fraud. And so he flagged my account, and subsequently they closed my account. Well, I said, now hold on now. Y'all got an arbitration clause. I said, now I want y'all to understand. I understand about arbitration. So they brought it to the arbitrator, and there was a judge who got pissed off at me, and he labeled me a vexatious litigant. I didn't care about that judge or his vexatious litigant. I know that that's illegal. But the judge did it. And so the attorney, when it came time for the arbitration, after I done paid for everything, when it came time for the arbitration, the attorney said, oh no, this arbitration can't go on, arbitrator. He got a vexatious litigant. So I said to the arbitrator, I said, look here, arbitrator, you can't be that stupid. You are the attorney. The courts have already said, here are the cases where arbitration has nothing to do with litigation. The arbitrator says, nope, you've been labeled a vexatious litigant, so I'm dismissing this arbitration. Oh, I said, no, you need to reconsider. And they ignored me. So I went to the main AAA in New York. I said, hey, yo, people over here messing up. Y'all need to correct this. Now, I'm giving y'all an opportunity. They ignored me. They didn't do anything. Now, hold on. They got rules. American Arbitration Association has rules for reconsideration and appeals. Yes, you can appeal in the American Arbitration Association. And so they ignored me, denied me the right. Well, that's a due process right. Why? Because they're sitting in the seat of government. They're operating under color of law. The Federal Arbitration Act is where they get their color from. They don't even see what I'm getting ready to do. But when I do, pay attention, when I do consults with people, I create GPTs for them, and I tell them you need to listen to the entire conversation, including when the system is talking and thinking. You need to go back and listen to that. Sorry, give me a second. Let's go back and listen to the thinking. This is the thanking. We gonna play just the thanking. I ain't gonna play the whole thing. Just the thanking. Yeah, let's play. We're gonna start right here. Okay, we're gonna start right here, and we just gonna let it play until we get to that point where I started. Come on now. Oh,
Calling the NCO Financial Systems Incorporated. No 15 CV 13470, 2016 WL 375, 3129, D. Massachusetts, July 13, 2016. Holding, the court granted a motion to compel arbitration and, pursuant to FAA 5, appointed a substitute arbitrator after the AAA repeatedly failed to respond to the claimant's submissions and effectively stonewalled the initiation of the process.
oops.
The court found the AAA's silence and inaction constituted a lapse.
Oops.
Dialysis Access Center, LLC v. RMS Lifeline Incorporated, 638 F.3d 367, First Circuit 2011. Holding, the First Circuit affirmed the District Court's appointment of an arbitrator under FAA 5 after the AAA refused to administer the dispute. The court held that the AAA's refusal did not void the arbitration agreement. Instead, it triggered the court's statutory duty to implement the agreement by appointing a neutral legal framework for your petition to compel with substituted appointment. Your petition should be framed as a combined action under FAA 4 and 5.
It sure is.
9 U.S.C. 4 party aggrieved by the alleged failure, neglect, or refusal of another to arbitrate under a written agreement for arbitration may petition for an order directing that such arbitration proceed in the manner provided for in such agreement.
I know. That's why I was doing motion to compel. Well, hold on now. See, they think this is your idea. This ain't your idea. This is me telling it where I was going. And it's confirming where I was going. This is page 28, so that's why y'all didn't get to hear all of that. Y'all gonna hear it in a minute. Hold on now. It's gonna tell y'all exactly what's going on and why I is what I is. 1 second.
Agreement. 5. 9 U.S.C. 4. If in the agreement provision be made for a method of naming or appointing an arbitrator, and any party thereto shall fail to avail himself of such method, or if for any other reason there shall be a lapse in the naming of an arbitrator, then upon the application of either party to the controversy the court shall designate and appoint an arbitrator. Tactical outline for your petition.
Thank you.
Title: Petition to compel arbitration and to appoint a substitute arbitrator pursuant to 9 U.S.C. 4 and 5 or to disqualify the AAA and appoint an alternate forum.
We're about to
Factual allegations supported by record exhibits. A. The valid written arbitration agreement governing the dispute. B.
Hold on, y'all. What you need to understand is AAA don't like me because we have an arbitration association that competes with them and they don't like us. They're a bunch of attorneys. They're officers of the court. Oh, I'm sorry, I haven't explained this to you guys yet. Oh, let me explain to you how the courts took over the arbitration game. Yeah, they got AAA and they got Jam. Oh, Jam, Teddy Jam. Okay, they got Jam, J-A-M. That's judges. And AAA, the American Arbitration, the American Bar Association, the American Arbitration Association. You feel me? Officers of the court. That's how the courts took over arbitration. Go ahead. Most of your contracts, it's either AAA or Jam. Go ahead. Bigger businesses, it's Jam. Consumer contracts, AAA. This is how they've taken over arbitration and they block you. So when you have organizations like mine, arbitration associations, okay, they don't like that because we're interfering, we're digging into their pockets. So they don't like me. So that was one of the reasons they did that vexatious litigant stupidity. But let's go on. Where you at? There we go.
AAA pursuant to that agreement. C. The arbitrator's dismissal on the improper, extra-contractual ground of a vexatious litigant order. D. Your timely filing of an appeal/request for reconsideration with the AAA.
Hold on. The reason why it says vexatious litigant is extra-contractual ground. There's nothing in the Federal Arbitration Act says nothing about no vexatious litigant and no court issued blah, blah, blah. And there's nothing in the agreement between the parties that says anything about no court orders or any of that stupid stuff. So because of that, the arbitrator had no jurisdiction. The arbitrator, that's what I expert in now. As an expert in that junk now, arbitrator must go by the agreement between the parties and the law. You see, the vexatious litigant only applies to court cases because it's a court order, and the court only had jurisdiction. Technically, it didn't have jurisdiction, but the court order only states with filings with the court. Doesn't talk about any other filing. And because of that, that's where they lose. Pay attention.
Citing a specific AAA rule that permits it, example Commercial Rule R53, or the applicable rule from the AAA's supplementary rules for the prevention of party driver delay and abuse. This is crucial. E. The AAA's failure and refusal to rule on your appeal, thereby breaching its own rules and creating an impasse.
You see, I asked them for reconsideration, and I asked them to appeal the decision, and I said, please, y'all, please, master, I must be good. And they said, mother, and so now they violated their own rules. Shh, pay attention. They had a duty to respond. They didn't respond. Pay attention. They lose jurisdiction. They lose immunity, but they don't realize it yet. It's coming. The battle round.
F. Correspondence demonstrating you put the AAA and opposing counsel on notice of this failure and its consequences. 2. Legal argument. A. The agreement to arbitrate is valid and enforceable under FAA 2. B. The arbitrator's dismissal was in manifest disregard of the agreement and FAA, as it was based on a court order irrelevant to the contract. This evidences partiality and misconduct. C. The AAA's failure to act on a proper appeal constitutes a lapse under FAA 5. Asterisk by agreeing to AAA rules, the party...
Now, we're gonna skip all of that. We're gonna skip again, too. Give me a second.
The court must intervene to prevent a failure of justice. The Supreme Court in Henry Schein Incorporated v.
Now, y'all know Henry Schein. That's how it's talking about, because I told it about Henry Schein and Archer and White Cells. 2019, the unanimous decision where Justice Kavanaugh gave the judge's opinion. Pay attention. He had just got appointed to the court. That was his first opinion of the court announcement. Okay? Now, hold on. I told it. Now, watch what the court did there that it picked up, and I'm so glad it picked up on it because I didn't have to, I inferred it. I didn't tell it this. This lets me know that it's on the money.
Archer and White Sales Incorporated, 139 SCT 524, 2019, forbade courts from inventing exceptions to arbitration.
See, it picked on that. You see, the court in Archer, there was this rule that the court said that they created an exception. The courts created an exception. Well, it picked up on the fact that the courts could not invent an exception to the arbitration rule. Well, that's what these idiots did. They invented an exception. Well, it says they must follow the act as written. Interesting, ain't it? They must follow the act as written. Well, let's see.
By the same logic, when the institution invents an extra-contractual exception, by ignoring its rules, the court must enforce the original agreement by substituting performance under 5. 3. Requested relief. An order compelling the parties to arbitrate their dispute is...
Okay, now, we're going to go down here. Why this approach is powerful? I'm sorry, the reason why I'm doing this is to let you know, the presumption killer. All you got to do is give your GPT instructions on what it's doing. The courts operate on presumptions. Don't listen to what they're saying. Nothing they say is truth. They're using a presumption. Even if they say something is the truth or is the law, you must understand they're lying. You have to know the law or you have to rebut the presumption. You don't have to do it right there at that moment, but you have to do it soon thereafter. You hear the presumption. You have to speak up on it. Don't just let it go, because then, according to their so-called stupidity, their rules on presumption, it stands. Nobody wants nothing on their stand. Come on, y'all. That stuff ain't got no business.
You are not asking the court to rule on the merits of the vexatious litigant issue. You are asking it to do two things it has clear statutory power and precedent to do. 1. Enforce the arbitration agreement.
Hold on now. You see, it says I'm asking you to do that because that's what I told it I was doing. Okay? It didn't tell me. I'm not going to ChatGPT for advice. You'll see in a second.
And 2. Fix a broken element of the chosen arbitral process. By highlighting the AAA's violation of its own rules, you frame its inaction as a breach of the incorporated procedural contract and a denial of due process within the arbitration, making the lapse clear and the need for judicial intervention.
I told him I was coming, y'all.
Compelling. Proceed with this dual-focused petition. The case law supports you. Synthesized case law supporting judicial intervention in arbitral institution failure.
Now, hold on now. Here's where it's going to tell you about me.
The user is asking me to provide documented cases where courts intervened when an arbitral institution, like the AAA, failed to respond to appeals or failed to act on reconsideration requests. They want to use this in a petition to compel arbitration and to challenge the AAA for impartiality.
Now, see, they say I wanted more cases. Now, watch this. Pay attention.
They want me to expand on these and potentially find additional cases. Let me search for more cases that support court intervention when arbitral institutions fail to act or ignore appeals.
Now, this was the GPT, Chat GPT, the presumption rebuttaler, the presumption killer. This was that one. That's why it says it cannot use sovereign citizen language or any of that other stuff. Okay. Then after I got it from here, I'm going to play it. I'm going to skip the sovereign citizen thing. I'm going to do the let me search thing. Go on, because let y'all know how it works.
Let me search for additional cases and provide a comprehensive response.
Okay. So she goes ahead and, it goes ahead and it finds other responses because it searches websites. And we're going to go to Jam. Where's Jam at? I saw Jam. Jam. Oh, Jam. Well, let's do AAA. Let's do AAA.
Using the AAA's rules to defeat arbitration requirements, NCLC Digital Library. nclc.org. Stiffing the arbitrators, the problem of non-payment in commercial arbitration. Harvard.edu. Synthesized case law from multiple sources to construct comprehensive response. Great. I have comprehensive search results. Now,
I tell everybody I have a console with, go back, listen to the conversation, especially the one from the GPT. It's thinking, because this is what this is how they think. See, you want to see how the other side is thinking. It's a presumption killer. You want to see what they're thinking. Now, notice what it says. It's preparing this for me. Pay attention.
I need to structure this in the user's preferred format with double spacing and facts/conclusions of law. The user specifically wants cases where AAA failed to respond to appeals or reconsideration requests. Based on your 42 years of experience in your specific situation, here is the...
Hold on now. 42 years of experience. I was just explaining to a young man who's incarcerated. I said I was going over this stuff, and I said, I have been doing this for 42 years. At the age of 15, I said, how many 15-year-olds do you know that are allowed to go into court and represent themselves in court? Represent themselves in court. How many 15-year-olds you know the court's allowed to do that? And I said none, because it's illegal. Ladies and gentlemen, unless a 15-year-old is emancipated, he does not have the right to speak in one of these stupid courts on his own. But I did so 6 separate times between the ages of 15 and 16. 5 separate tickets, well, 4 tickets, but one I had to appeal, and I won an appeal, which means I won the original case that I originally lost, and I didn't even articulate that until tonight, because I never thought of it that way. I thought about, 4 out of 5. But it turns out it's actually 6 out of 5, because I won the appeal, which was the 5th case, and then I won the 4th case, which constitutes a 6th case. And since the first case, pay attention, was overturned, that's 2 cases, not 1, when you do the math. Some of you are not going to be able to do that math because it's going to sound strange to you. No, it isn't. It's 6. Because when the case was overturned, that overturned the judgment for the court. After the court made the original judgment, which converted the original judgment to a win. So that's 2 wins in the same court, plus on appeal. My first 6 cases by myself. And they knew, even on the appeals court here in California, that I was 15 when I handled that appeal. Do you feel me? So when I say I have been practicing law for 42 years, I'm not making a joke about it. It's well documented that I was speaking on my own behalf and giving, pay attention, legal advice in the courtroom. Everybody saw me, including the attorneys that were standing around listening to me tell people what they needed to say and do. Okay? And them smiling and shaking their head in agreement. And it was that 16-year-old, well, the 15-year-old too, because I had always been told, go in and listen to how the cases go. Get familiar with the court. And so that's what I do. And I used to tell people that. Go and sit and listen to that judge. See how that judge acts and get to know who that judge is. That way you'll be able to deal with that idiot. And listen to the attorneys and listen to what they're saying. That's what I did as a child. So when I say, pay attention, I'm a 16-year-old, 17-year-old, 18-year-old kid, 19, 20, 21, 22, going into the courtroom with pen and pad and taking notes. I dare anybody to challenge me on what I know. And I mean that seriously. I'm not doing this to prove that I'm better than someone else. I'm doing this to prove that I am more than competent to handle this. And I dare them to ever bring me to court saying I'm practicing law. By all means, I practice law. Now go ahead and get me for the unauthorized practice of law. I dare you. And I'm not joking when I say that. What? I'll turn the system on its head. Look, there can't be any so-called thing of unauthorized practice of law because everyone is required to know the law. The moment they come after me, all of you are free. You can say you're ignorant of the law from that point on, because if you need to be licensed or get a bar card in order to talk about the law, pay attention. The Supreme Court said you can have any common occupation, and everybody's required to know the law, so that means knowledge of the law is common. It's a common occupation. Everybody has that right. State doesn't get to regulate it. Why? Because they don't have the authority. Once they regulate it, that means it's no longer a right. It's a privilege. You can only regulate a privilege. That's why they can't regulate the private citizen. I use the word citizen, I apologize, but they can't regulate a private party, a private person. They can't do it. Why? Because it's not a privilege. Congress does not have the right to regulate privacy. Privacy is protected by law. Don't believe me? Go back and read the Bill of Rights. That's what it protects. Your right to privacy. That includes your right to property. Wait, hold on. Let me see. Oh, I hope it's still up. It may not be up, y'all. It may not be up. I should have put y'all on pause, but that ain't it. That's a different doc. Let me see. Nope, that ain't it either. Y'all, let me go get it. Y'all hold on, okay? Get out of here. I know I opened up Opera. Hold on a second. I've been working on this thing for quite some time, y'all. This is a declaration. You know how they be taking your property rights and they be selling all your information and then telling you we got a data breach and all of that. And we got one for the corporate, one for the personal. See? Representative declaration. And then we have one for is a notice and addendum letter. See, this should tell you it's a conditional acceptance letter. Ooh-wee. Yeah, you want to hold my information and sell my information and do all that? Well, here you go. Y'all don't know. I'm getting ready to play because I ain't got time. We're going to be telling y'all about this in a moment, okay? Doesn't matter if people want to take this idea and run with it. I don't care. Because, like I said, this is the year of the lawsuit. This is the year of we changing some things, okay? Oh, no, this year, I told you, it's multifaceted. It's not just one or two. This year is until I say it's over. And I ain't ready to quit. Okay? Because I'm too legit to quit. Hey, too legit. I'm sorry. Hammer, you know I got loves for you. All right, ladies and gentlemen. I'm doing this to let you know. Do yourselves a favor. ChatGPT, create your own presumption killer. All you got to do is tell it what role you want it to play. And you want it to kill presumptions. And the first thing, if you got a court case, you take those court decisions, all of that junk sent by the court and by the opposing counsel, and you put that into it. And you tell it, give me a list of all the presumptions. And it will give you a list of all of the presumptions. And you say, you left some out. And it will give you a list of the other presumptions. And then you'll tell me, now, I want you to rebut each one of those presumptions with facts and conclusions of law. And when you rebut the presumption, you must do so with an irrefutable, IRR, and then effutable, EFUTABLE. Anyway, irrefutable rebuttal. It will give you that. Now you say, if you can give me an irrefutable rebuttal, you have to back that with facts and conclusions of law. And if you're going to give me a U.S. code, now this is the most important thing I've said all night. So you need to pay attention to this. When your GPTs give you codes, you want to tell it if you're going to use a U.S. code or a state statute that is codified, you must include the original Senate bill and or statute at large with that code so as to verify it. Include the statute at large and or the assembly bill with all of your codes. Hold on, let me see if it did it. Because I know, see, stat for, there we go. And you see stat, and then, man, okay, that's what you do. That's what you do because it's going to keep giving it to you because it gives it until it hurts. See how it gives me my statute at large? That's how you fortify your document. Why do you do it this way? Because they cannot challenge your rebuttal. It's irrefutable. Why? Because to challenge your rebuttal, people pay attention because it's so important. To challenge your rebuttal to their stupidity would mean to challenge the law itself. And they can't challenge the law itself because they would have to declare the law unlawful, unconstitutional. Oops, my bad. That's why you do both the code and the law. Okay? That's what this is all about. And you turn yourself around, you see, because that's what it's all hokey pokey. Anyway, I am so grateful that I am here at this stage in this life of mine. Why? Because as of tonight, I'm on cloud 9. The presumption killer has had the effect I wanted it to have because those idiots went to ChatGPT trying to get them to stop that one GPT. Look, ChatGPT has 700 million subscribers. Why are they worried about me? They shouldn't be concerned about me. But they are concerned about the presumption killer, and the court should be concerned about the presumption killers because I just told you how to defeat those idiots with their little stupid petitions and motions and all of that junk that they be giving y'all. You defeat them by challenging them because judges are not smart. They go to school. Attorneys and judges go to school to argue presumptions. That's why they're arguing all the time. That's why they want to hear, okay, I will listen to your argument. Okay, I'm not persuaded by your presumption. That's all they're doing is presumption. So kill the presumption from the very beginning and say, I'm not here for presumptions. I'm not here to argue. I'm here to talk about the facts and conclusions of law. Now, if you don't know what that is, I'm going to teach it to you. You're going to learn something today. Okay? That's what you're telling them. Because I promise you, that's what I'm telling them. That stupid hoe, Ada Delgado Colon out of Puerto Rico, she's a hoe. And she knows she's a hoe. She rocks 8 different freaks after every show. Okay? She's a hoe. I'm not going to take that away from her. That big head hoe, that woman's head is bigger than mine. Oh, Lord. Yeah, I'm talking about that hoe. And I can talk about her because of what she did. And she knows why I'm calling her a hoe. Because she slept her way to the top. Anywho, told me I wasn't going to be teaching no class in her courtroom and denied me my right to speak for myself, even though I had been through 7 psyche evals in that one case. 7 psyche evals, people, and passed all of them. The one I didn't pass because the doctor got mad at me because I wouldn't talk to him because I told him he was an idiot and I wouldn't talk to him. And so he declared me incompetent because I wouldn't talk to him. And his supervisor said, wait, what are you doing in here? I said, oh, I don't know. I guess they didn't like me. He says, you mind if I talk to you? I said, nah. And he sat down and we talked for an hour. It got to the point he says, look, no, look, let me tell you what. No, I'm gonna remove that. I'm gonna declare that you are competent. But if you want to stay here, this is a nice place and the people here are okay and you won't have any issues. I said, no, I need to go back because I made a lot of promises over there to help those people and I need to help them because I gave them my word. That was my experience. So 7. And the math that I do, that's 8, because he overturned the other idiot's decision. And all I did was ask the first one, where did you get your law degree? And are you a lawyer? And he told me, well, I don't have a law degree. And I said, well, then how are you a doctor who's here to evaluate whether or not I can speak for myself in court. But then to do that, if you yourself are not a lawyer, are not a student of law. And he told me, well, we'll meet again on Thursday and then again on Friday and possibly on Saturday, and I'll send my report to the court. I'm still waiting for Thursday, Friday, and Saturday, y'all. I've been waiting all that time. That man said he was going to come back and we were going to meet again. I just don't know what's wrong with these people making these schedules and these appointments and not showing up. So when I say I don't mind, I'll play the game, but I'm not playing games anymore. I'm too old for the games now. I was playing games back then because I was testing the system for you all. I'm not testing the system for y'all no more. I've already proven what the system is to all of you by going into the belly of the beast. Okay. I am so glad we had this. Hey, how y'all doing? Get off that beach. Y'all know there's sharks in the waters and they attracted to white folk. What? Sharks don't bite black people. They only go after white folk. What? Y'all didn't know that? What? They're prejudiced. I'm sorry, just kidding. I'm kidding. No, I'm not. Okay. Ladies and gentlemen, it's time to let y'all go. As you see, I'm in a great mood because I told them to leave me alone. I always tell them to leave me alone, and they think they can handle me. So I'm going to let them handle me. The only thing they can do is threats. That's all they have are threats. They're not smarter than I am. Now, hold on. I know I said smarter. You heard me use the word smarter. The proper way of saying that is more smart. But I said smarter, as if there is a way to be smarter. There is no way to be smarter. You can only be more smart. But I don't care because I don't consider myself to be smart. They do. That's why they say that. All my life, people have been saying, you're arrogant. And I will be arrogant. They were calling me arrogant. I didn't even know what the word arrogant means. If arrogant means that I have too much confidence in myself, then they were lying when I was younger. Because I didn't have any confidence in myself. But, man, by the time I was 26 years old and I went in front of that mirror and I found 10 things about myself that I like, and can't nobody sit up there and challenge me on how I feel about me. Okay? I loved it, me, some me. Just understand it. I loved it, me, some me. And you all should learn to love yourself too. All right. On that note, you see we got a storm coming in. I'm going to let y'all go because this looks like it's going to be a pretty powerful storm. And them poor people in the houses don't understand what a flood is until after this storm comes in, huh? All right. Y'all take care. Arriva Maderci. Bye-bye.